to a number of people, and again, we're thrilled that you opted to include us in your morning on this beautiful Saturday. How many alumni of the college, pardon me, in this room, alumni are here? Wonderful, perfect. And so any parents of St. Mary's students? Okay, fantastic. And some community members, I know. We also, wonderful. And I know there are some clients here, Michelle's, possibly Mercy's, I'm not sure. Well, delightful. The presentation this morning, we hope will address questions and thoughts you've been having. If you didn't have a moment earlier with Courtney Bennett, who I should have introduced Courtney in the back there. You met her when you first came in. She's got some index cards. I think she passed those out. And so if you've got some thoughts throughout the presentation, we're happy. Near the end, we're going to reserve about 15 minutes for a Q&A for both Michelle and Mercy. Okay? Lisa.
Well, again, thank you so much for being here this morning. We are so grateful to share a Saturday morning with you. We are, at St. Mary's, a robust institution that many of you would be familiar with, of course, as alumni. And for those of you who are maybe for the first time, welcome to our very beautiful campus. Our community is always welcome, always invited to share in this space, to come for a variety of activities, events, and even just to enjoy a beautiful Saturday afternoon on campus. Please come and join us anytime. Just a little bit of history. St. Mary's College has been established for 154 years. We started in San Francisco, moved to Oakland, and found our home in Moraga in 1928. So we have been a part of this community even before this was really a robust community, that's for sure. Our history, though, is founded on the generosity of all of those who have come before us. So estate planning, whether it be for St. Mary's College or any charity that is meaningful to you, is an important part of our culture and our community. And so that's why we are so excited to bring this information to you that we hope will be informative, educational. I am looking forward to learning more from these amazing women here who are here to present to us today and to share in this good information. So again, we'll all be here throughout the entire session. Any questions, if you want to learn more about St. Mary's, please don't hesitate to ask Carolyn or myself, and just enjoy the morning. So, Carolyn, thank you.
Thank you very much. Speaking of amazing women, it is my pleasure to introduce one of the two amazing women that are presenting with us and to us this morning. I'm going to refer to a couple of notes here so that I make sure to say all of the things I want to say. Michelle, please join me up here for a moment, would you? So, Michelle Perry Higgins, a proud Gale. Hey. Oh, claps in the room. Yeah.
Wake up!
Alumna of St. Mary's.
You can tell
College.
my clients are in the room.
That's right. That's right. Well, maybe one of them wants to introduce you.
Yeah,
they probably have a good sense. Anyway, so Michelle is a financial planner and principal of California Financial Advisors in San Ramon. She specializes in wealth management. You may or may not know this, but she is an award-winning expert in her field. I will not begin to list all of the things. And I should pause here to say, in your packet are a number of materials, one of which is Michelle's full bio, but there's also a slide deck, a copy of the slide deck that Mercy will be going through in a little bit in case you want to make some notes. But back to Michelle. She is a frequent public speaker on this topic and will enjoy some of her remarks this morning as well. She's also the author of 3 Amazon bestsellers, including The Everything Binder, Financial, Estate, and Personal Affairs Organizers. I know you brought a couple examples of those in the back of the room, so if folks are interested, you can take a peek at those on the table in back. And as I mentioned a moment ago, Michelle is a proud St. Mary's Gale. Yes. She's also the vice president of our Board of Regents, which is a leadership volunteer body here at St. Mary's that supports our advancement efforts, and a member of the Women's Leadership Council as well.
Thank you.
You have a family, but I'll let you talk about them if you so choose. And with that, I will say thank you, Michelle.
I do have a family. I have 2 little ones. I have a teenager this morning who was heading off to many of her events. She's a freshman at Monte Vista in Danville, and so I never quite know what's coming down the stairs. Many of you who have had daughters are with me on that one. And then I have a little one that's just about to approach those years where it's coming, where she's changing from the sweet little girl to a beast. And she's in 6th grade. So I am so happy to be here because my husband's dealing with them this morning. But thank you for having me. Thank you for hosting. There are 2 things that I always say I'm very passionate about, and one of them is educating women, and I'll talk about that here shortly, and the other one is raising scholarship dollars for needy college students. And so that's how I've gotten involved with St. Mary's College, because I've wanted to find a way to give back because I was lucky enough to come to this school and get a tremendous amount of scholarships. So that's kind of been my my thing, if you will. The proceeds from College Poor No More and my books come back to helping scholarship funds for students. So my passion and love educating women, empowering women. As a money manager, financial planner, I have women that come into my office and they have this scared look on their face, like, oh boy, I don't even know where to start. And it's overwhelming, and I get it. And just because I love it doesn't mean every woman loves it. Who wants to talk about insurance, money management, estate planning, yachty budget, this, that? What happens if my husband passes away? There's a lot that goes into what we do, and we love it, but we want to make it so that you understand it. And it's not my goal to talk over you. It's not Mercy's goal to talk over it. We want to empower you today so you can go back and then make great decisions for your family. And I'm going to share with you some stats that are profound, and I don't think a lot of people are talking about this or realize that by 2022, two-thirds of consumer wealth, two-thirds in America, will belong to women. 80 to 90% of women will solely be responsible for their finances at some point in their lives. Now here's the kicker though, only 2 in 10 women feel prepared and ready to take over their finances. And so that's what I work so hard every day, is to empower women, because each one of you, just based on the sheer numbers of stats, you are going to be controlling your financial plan and your estate plan. God forbid your partner, spouse, something happens to them, you are in charge. And so what do we need to do to get you to a place where you're not scared, you're not afraid, but you say, okay, we can do this. And that's really where myself and the college said, okay, we're going to start doing a series of seminars to start educating women. And that's how this all kind of birthed. So with no further ado, I'm going to get Mercy up here. She has put together a beautiful, oh yes.
Quick question. So we were just kind of discussing the reason that it's going to be 2/3 women is because the women are outliving the husbands?
Yes.
Or a change in culture that there are more single women? Or?
No, it's definitely women are outliving men. Divorces is the other kicker.
Okay. And then you're talking about nationwide, California?
In America, nationwide. Yeah. So today some of the big topics Mercy's going to hit. Why is estate planning different for you, for women? What happens when you fail to plan? You know, we don't want to talk about the worst, but it's important. Let's face it. These are the things that are going to happen if we fail to plan. What can you accomplish with a financial plan? We want to cover where's there the value. Incapacity, asset distribution on death. The good old taxes, we got to talk about that. For those of you that are business owners, business succession, and then charitable donations. Where are there strategies that we can bring into the estate planning with charities? So that's what we're going to cover, and definitely leave a lot of room for questions because I'm sure things will come up. Mercy, why don't you come up? Mercy is also an alumni of St. Mary's, which is so exciting. She is the principal of Hall Law Firm, representing clients, which is in not only estate planning, but special needs. And this was really important to me also when we brought Mercy in, is she has a niche of her market where she specializes in special needs trusts, conservatorships, settlement planning, probate. And she was fortunate enough to start her own firm, but prior to that, she worked with Sterling Terry Ross, who many consider is the originator of special needs trusts. So I'd love for you to talk about that a little bit. So I will let you jump in and let's get going.
Thank you. Thank you.
And I think you're going to save questions for the end, right? And then
For the end,
you and I will
unless-
hit them at the end.
Yeah,
Okay.
that
Perfect.
sounds good. This is a good place to
Okay.
So thank you everybody for coming. It's great to see everybody here. I know it's an early on a Saturday, so I really appreciate the opportunity to talk to you about the estate planning and Michelle, the financial planning. As Michelle mentioned, I have my own law firm, and I solely focus on estate planning and related issues. So I see a lot of situations with people who are elder or disabled, and a lot of situations where people can be taken advantage of. So one of my passions in empowering women as well is to make sure you have a plan in place that's going to communicate what you would want to happen if something does happen to you or one of your loved ones. If you don't have that plan in place, you're likely not going to be happy with what has to happen to get some authority to make decisions. And we'll talk about that in a little bit. I live in Marin, and I have one son who just left for University of Washington, and I have a much younger little one who's about 20 months, and she's my little baby beast, and it keeps me busy. And then my office is in San Francisco, but I do work all over the Bay Area and some work in Southern California. So I see a lot of what's going on with women when they don't have a plan in place, and so I'm really happy to be able to talk to you about that today. Courtney, maybe we can go to the next slide. Great. So why is estate planning for women different? So it tends to affect women in a much different way than it does men, and more profoundly. And again, as Michelle mentioned, statistically women still outlive longer. And so their assets need to last longer than if their life was shorter. Typically women have earned less, either because they've been in the workforce less from raising children, or just statistically women are making less on the dollar than men. The likelihood of their incapacity during their lifetime is much greater than for men because they're outliving men. So as you age, you're more and more likely to get dementia or other forms of incapacity. Women tend to be the primary caretakers of children and parents. This can affect their accrued retirement benefits. So if you're out of the workforce, you're not contributing to Social Security, and also sometimes your 401ks and your IRAs. So that can affect your accrued retirement benefits. And they also have very strong opinions about what happens to their kids or their parents if they pass away. Women's goals and interests around finances and estate planning tend to be very different than men. And I don't think I would be surprising anybody to say women and men view things very differently sometimes. And if you don't put your interests and your goals down in a legally effective document, you're left to some decision making that might not effectuate what you want. So, not to scare you, but I see a lot of what happens when people don't plan. There's a lot of business out there for attorneys who need to deal with emergencies when somebody doesn't have a plan in place. So I wanted to kind of briefly go over what does happen if you don't put a plan in place. I think a lot of people think, I don't have that much money, I really don't need to put a plan in place. I'm not that worried about it. My kids or my husband or somebody else knows what I want to happen. So, as I mentioned briefly, without a legally effective plan, your wishes may not be known or they might not be carried out. I think when somebody passes away, their loved ones often get into this extremely emotional state, and intellectually they may know what you want, but emotionally it may be very hard to carry out. And so if you don't have a legally effective document that can make that happen, it may not happen. The death of a loved one or incapacity of a loved one often throws families in conflict. I have families that have always gotten along, who've always been very close, and when a parent becomes incapacitated or passes away, things come out that you would be amazed, and it affects a lot of people. There's also a greater likelihood of being taken advantage of if you don't have an effective plan in place. So, for example, California started something this last year called a transfer on death deed. And a lot of estate planning attorneys who see elder abuse really fought this because it's a very simple deed that once you sign it, has the effect of transferring it to the person you've indicated on death. What that means is that there aren't a lot of protections in place if you've got an elder person with a home or other real estate, and somebody comes into their lives and convinces them that they're taking care of them, and they should compensate them somehow. It's very easy to get that individual to transfer over the real estate to this unscrupulous caretaker or other individual. If you become incapacitated, your loved one.
What is it called? Transfer on what?
Transfer on death deed. If you become incapacitated, your loved ones may have to go to court to get authority to deal with what you need to have happen. So I do a lot of conservatorships for people who are elderly, have become incapacitated because they have dementia and they don't have a plan in place. Oftentimes the individual needs to have care providers brought in or get some medications administered, and other family members not only can't access their funds, but they may not be able to move them or to do some planning to perhaps get them on Medi-Cal to provide for some nursing home care. So these are all things. So in that situation, you have to go to court, and it's a very involved process with court investigators. It's very expensive, and you're reporting to the court on a regular basis. You also lose important tax planning opportunities. So what we'll touch on a little later is there are a lot of different taxes to think about in your financial and estate planning. And you can accomplish a lot of those if you have documents that do this with the proper planning. If you do nothing, you're going to lose a lot of those opportunities. If you have any loved ones with special needs, they can lose access to important benefits. So if you are leaving an inheritance to somebody who has special needs and maybe on public benefits, they can all be disqualified for those benefits when they receive the inheritance. You may have to go through probate. So in California, if you have more than $150,000 and you don't have a trust, then you have to go through a formal probate process, and that's very expensive and time consuming. So it takes a minimum of 18 months, often longer. It's expensive because both the attorney and the personal representative get paid a percentage of the assets, not the actual work they do, but a percentage of the assets. It's a public process. Everything that you have is published. There's a publication in a newspaper. It's in an open court process. Anybody who's interested can find out what you have. And it's court supervised, so you're going back to court a lot. So it can be very complex. So on the flip side of that, we have an opportunity with estate planning to address a lot of these issues at the front end and really lay out what you want to have happen. You've worked your whole life to, put your finances in place, to have a certain lifestyle, to, you have opinions about how you would like yourself taken care of when you're incapacitated, or perhaps your children. And this is really the opportunity to make sure that happens. So you can plan for your incapacity, provide instructions for managing both your personal and financial affairs. If you become incapacitated, you get to say who gets to make those decisions. You can't provide for your dependents when you cannot. If you have an accident while your child is a minor and you want to make sure that that child's taken care of, this is a really important opportunity to plan for that. If that doesn't happen, it's possible you're going to be going to court to deal with a guardianship. You can facilitate Medi-Cal planning if necessary, and this really comes into play for people who don't have a long-term care insurance policy, and perhaps Michelle will talk a little bit about those policies later, but a large majority of people don't have a long-term care policy, and if they need nursing home care, may need to qualify for Medi-Cal. With proper planning, we can get that to happen without having to go to court. The major reason people have an estate plan is to create an estate to leave to your heirs and to make sure the distribution of those assets happens the way you want them to. You ensure your heirs receive assets, and we'll talk a little bit about making sure they're protected and that the assets don't go to some other unscrupulous person. You can protect your minors or young or immature adults and those with special needs. So we'll talk a little bit about possibly setting up trusts for kids who may not be ready to handle a lot of money. Maybe they're adults and they're age 18, but most 18-year-olds don't have the capacity or the financial sophistication to, hold on to that money, manage it, and facilitate their own estate plan. You can plan for continuation of your business. That's really important if you own your own business, because otherwise your leaving those decisions up to somebody who may not understand what your goals are. You can plan for your charitable goals, and we'll talk about that more in a little bit. You can reduce or eliminate taxes, and you plan for guardians for your minors or conservators for any disabled adult children. You can also designate who you would like to be a conservator of yourself if one is ever needed. So the first section we're going to talk about is incapacity. We talked a little bit about what happens if you don't plan. These are the documents that we would put in place to plan for your capacity. So the first and primary document is the durable power of attorney for financial management. It allows you to designate somebody who takes care of your personal and financial needs. It can be anything from paying taxes to managing assets to working with a trustee if you have a trust to coordinate the different things that you need done. You can grant powers that allows the agent to continue and implement your estate plan. So if you're in the process of creating an estate plan and something happens to you and it hasn't been finalized, or you've got a plan that takes some stages, the agent can finalize and implement that estate plan. They can do some tax planning and qualify you for Medi-Cal. The Advanced Health Care Directive is another really important document because it designates somebody to make medical decisions for you if you cannot do so. You can also give instructions for end-of-life pain management and care. And we can also decide in these documents, how do you determine if you're incapacitated? Because most people think, well, you know, there's some people that I would feel comfortable saying, okay, they're not able to handle things anymore, and others I'm not so sure. There's a couple of different options. You know, you can say something like, one doctor can certify that I'm incapacitated, or I want 2 doctors to certify I'm incapacitated, or I've got this group of family members that I'm going to call an incapacity team. And I'm going to say if those 3 people agree that I'm incapacitated, that's enough to trigger some of these documents. The third document that we include is a HIPAA release. And the reason this is important, HIPAA allows a doctor to disclose your medical condition to the people you designate. The release does. Why this is important is that you need a doctor to be able to say to your agents and also a trustee of a trust if you create one, this person is in fact incapacitated, or you know, they're incapacitated today but we think they're going to come out of it in the next couple of days. If you don't have this HIPAA release, there's very little the doctors can communicate to your family members, and you could run into some problems even if you've done something like pulled the Advanced Health Care Directive offline and completed it. So another part that we do estate planning for is asset distribution on debt. So the documents that we use to plan for asset distribution on your death are these: the revocable living trust, the pour-over will, an assignment of property, and something called a personal property memorandum. The revocable living trust is really, in California, the meatiest document that we use. You'll see something a lot of times along the lines of 30 to 50 pages, but you know, don't be afraid of that. Can be a very thorough plan. So the revocable living trust is what we call a probate avoidance device. So if you have your assets in a revocable living trust, it's likely you will not have to do probate. That keeps it out of the court. It's less expensive because only the work that is done is paid. Usually there's an attorney involved, but they're only paid for the time they actually spend doing work, not a percentage of the assets. It's private, so it's not part of the public record. Nobody has to know who gets what out of your estate plan. It's a really important place to do some tax planning. So, and we'll talk a little bit more about taxes in a little bit. And it's also the place where you outline how you're going to protect your heirs and your assets. And so this becomes really important in a lot of situations. If you've got a married couple and the first person passes away, the second person may wonder, you know, what's going to happen? Maybe I should just get all of the assets and manage it. Well, what if that second spouse becomes incapacitated and somebody comes into their life and, you know, maybe has some undue influence and takes advantage of them? How are you sure that your kids are going to get assets, for example? So there's ways to plan within the living trust to ensure that your kids get some of the assets while still providing for the surviving spouse. Your pour over will is basically a backup document that says if I forgot to put something into my trust, I'm directing that it goes into my trust. The assignment of property relates to any property that's not easily titled. So we're usually talking about your furniture and furnishings and personal property items. And the personal property memorandum is an opportunity for you to leave items of sentimental value to specific people. And it's a document that can be updated over time without having to go back to the attorney. A special needs trust is another really important component if you have a special needs individual. You can create it in conjunction with your living trust. It can be a separate document, which is typically what I do, or it can be part of your living trust. And it allows you to leave an inheritance to an heir with special needs without affecting their public benefits. But it also allows you to do a lot of planning for that individual. It provides a financial management tool for somebody who can't handle it themselves. You create a team to provide for that person's personal needs. You can say, I want a care manager hired, and you really lay out your intent for the use of the funds for that individual. And then I often do that with a memorandum of intent, which is a set of instructions to caregivers and those who will be providing for somebody with special needs. That is separate from the document and can be updated over time. There are other additional irrevocable trusts that you can create, such as a life insurance trust, a family or children's trust, and charitable trusts. So life insurance trust, they aren't always used anymore, but occasionally used to hold a life insurance and pay for life insurance policy. Family and children's trusts are really where we protect children who will eventually have capacity, but perhaps they're too young to manage assets if something were to happen to you right now. And charitable trusts can help accomplish your charitable goals while obtaining tax advantages. So I know some people are saying, well, I don't have that much, you know, why would I need to do an estate plan? There's an opportunity to really create an estate and fund an estate plan through some financial tools. Primarily, we look at life insurance. You can obtain a life insurance policy that is either payable to your heirs directly or payable to a trust. So for example, let's say I have $1 million policy for my kids. I'm pretty sure they're not going to be able to manage it if I were to die tomorrow. My older son, maybe he could manage it, but I'm going to have some concerns about that. My youngest one wouldn't even have legal capacity to accept the funds. So then I would direct those funds to a trust, because otherwise we're going to have to go to court and get a guardianship to manage the assets that would go to that individual. Retirement plans, I'm sure you know a little bit about retirement plans. Michelle will talk a little bit more about that. You know, a way to put aside some money and allow it to grow. And those retirement plans can also be paid to individuals or to trusts. And you can still get the stretch out benefit on IRAs while paying it to a trust. 529 plans, I'm sure a lot of you know about that, with saving for college and educational needs. And ABLE accounts are a lot like 529 plans for people with disabilities, and basically the expenses are paid for disability-related expenses. So the tax portion, there's a lot of different taxes to think about in estate planning. So primarily we think about estate and gift taxes when we're doing an estate plan. There's something called a marital deduction. So we do a lot of marital deduction planning. That rule basically says if I'm married, I can leave all of my money to my spouse with there being no estate tax on my death. But if I have enough money that there's going to be an estate tax on my spouse's death, then they could get an estate tax. So marital deduction planning is a way to utilize both estate planning deductions. So sometimes we still use that. Generation skipping transfer tax. The short of that is basically people used to leave money to their grandchildren instead of their kids so that they could get money to their heirs and skip a generation's worth of estate tax. And so sometimes, so this rule was created that says you can't do that. You know, it gets taxed. And so sometimes we have to do some planning around that if there are enough assets. Income and capital gain tax. So there's different rules about what is the basis of your asset if I were to die today versus if I transferred it to my kids and then I died. You know, would there be a capital gain tax if they then had to sell the property? Property taxes, there's some exclusions available to spouses and to people while they're living in their homes, so sometimes we'll do some planning around that. Taxation of non-citizens, so sometimes people don't realize that either if one of the spouses or an individual is not a U.S. citizen, there are different taxes that apply. Sometimes if you're creating a trust, you can run into some tax problems with if a trustee is living outside of the U.S. So we do a lot of planning around that. And business valuation strategies. So if you do own your business, there's different estate planning products that we can put in place to get a really good valuation on your business. Or if we want a low valuation on your business so that your tax is not as high. So if you own a business succession planning is really important. You want to ensure that your business continues and is transferred as you wish. If you don't do business succession planning, then whoever can make legal decisions about your business when you pass away will do so, perhaps without doing what you would prefer to have happen. You want to think about things like, are you making transfers to both family members and non-family members, and how is that management going to play out? Some family members may be involved in the business and you may want to transfer the business to, let's say, one of your kids and make an offset for another kid that is not the business. There are some issues with transferring stock options, so we plan around that. We look at what stock options, what the rules are for that particular stock option, and how we can transfer that. There are other business interests that we need to plan for. So for example, if you have any copyrights, intellectual property, or other intangibles, this is an opportunity to plan for the transfer of those assets. That has to be done in a very specific way. There are tax issues when it comes to business succession, and so this is another opportunity to plan for your taxes that will come up. And there are special requirements for specific industries like medical corporations or law practices. There's laws that say you can only transfer them to other professionals with the same license. So it's also an opportunity to accomplish your charitable goals. You want to make sure that your charitable goals are known and implemented. There's different timing and different tax treatment depending on whether or not you do it during life or on death. And we plan for all of this with estate planning. You want to know which organizations qualify. So sometimes people come in and they say, I want to leave money to the Blind Babies Foundation. Well, you really want to think through, is that the local organization, the national organization? Are they in fact qualified as what we call a 501c3 entity, which would qualify for a charitable deduction for you? There are allowable deductions, and we have to talk through which ones are allowed. There are annual limits on your charitable goals. And we look at different vehicles for implementing that charitable planning. So that can come in a number of different ways, and I'll have Michelle talk about that in a little bit. That can be other estate planning vehicles like trusts, but there are other vehicles in which we can do some of this charitable planning. And so Michelle, maybe you would like to come talk about some of the examples of how some of your clients have implemented some of the charitable planning.
Should we do questions? Because I'm wondering that charity might go into a lot of other stuff I want to talk about too.
If you had questions that you wrote down
Let's
on
do our
index
questions.
cards, I can go around and collect them.
I don't know if you can read them, right? Can I just ask?
You want to read it out? Yeah,
Let's jump
please.
in with the questions.
Okay. I have a revocable living trust.
Right.
How often should you update it? Should it be after perhaps a spouse passes away, and then you change the title of the trust, then you redo the trust?
So there's a couple of different situations in which you want to definitely check in with your attorney. So at a baseline, I would recommend every 3 to 5 years check in, because there are laws that change and they can really affect your planning, and your goals may have changed. The people you may have designated maybe can't do it anymore. So it's an opportunity to talk through that with your attorney. In terms of life events, any major life event, you want to check in with your attorney. So if a spouse passes away, you need to take a look at what the document says. Some documents say you've got to split them into separate trusts. Other documents say, you know, it continues on as is, and the survivor has a real opportunity to do some other planning, so that's a good opportunity. You know, if you have children, have somebody pass away, somebody becomes incapacitated, all of these situations are really important to check in with your attorney.
Thank you.
Good morning.
Good morning.
I have a question with regards to the transfer on death deed. Once that's signed, can it be revoked or changed or canceled?
It can be revoked, so any deed is effective when it's signed. It doesn't have to be recorded to be effective. But usually the situation we're most concerned about is when it happens when somebody has started to decline in their capacity. They may sign the deed and not have the wherewithal to realize they need to revoke it, or not have the ability to revoke it. So, you know, one example is grandma signs a transfer on death deed to, you know, one of the grandkids or even some caregiver. The family finds out about it and says this isn't okay. And at that point, grandma doesn't have capacity to do a different deed. So then you'd end up in court having to deal with that.
And then a follow-up to that. So if a transfer on death deed is done and let's say dated from March 1st or whatever, say grandma signs another one a month later to someone else.
Yeah.
So what happens in that particular instance? Now you have two deeds out there. Does one supersede the other, or
Right.
probate here we come?
Yeah, no, so it's a sticky situation, as I'm sure you can imagine. So conceptually, the second deed would trump the first one, but there are a couple of different things. You know, one of those individuals may try to get down to court and get that deed recorded, and so there's some question about, you know, which takes priority if it was recorded first. And you may very well end up in court if the first person's alleging the second person was exerting undue influence. So it's a very difficult situation.
I would like to know under what circumstances a revocable deed or trust does not guarantee one staying out of probate. You said most likely.
Oh, right.
Mhm.
So we talked a little bit about a pour-over will. It says if you forgot to put something into your trust.
Mhm.
Occasionally, somebody will either forget they have an asset or not know about an asset and not title it in the name of their trust. And if that asset is large enough, then you may have to do a formal probate. It doesn't happen all the time, but I've seen it in my practice.
Okay.
Yes.
Yeah, and I would say particularly where somebody leaves them an inheritance that they didn't know about.
Say that again.
When somebody leaves, so let's say you have a revocable living trust,
Right.
and a family member you didn't know was going to leave you an inheritance, leaves you an inheritance,
Oh, okay.
and you don't know about
Right.
it, so you don't get it into the trust, and
Mhm.
perhaps by the time that occurs, you've lost capacity, you don't have the ability to put it in your trust, then you could end up with a probate situation.
Does everybody understand the terminology of putting assets into the name of the trust? Because I have a lot of clients that are a little confused about that. Do you want her to walk through
Yeah,
that?
that would
or
be
is
actually
Yeah,
good.
thank you
Okay.
so much, Michelle.
Because I think it's important. I kind of use the example, the trust is like a suitcase. And if we're going on vacation, we got to put the clothes in the suitcase. If you don't put the clothes in the suitcase is useless. So a trust really, there's great value in it. But if you don't actually fund the trust, then all that work you did in planning, then you still have to go through that process of going through
Yeah.
probate, which is the last thing you want to go through if you can avoid or have your heirs go through. So maybe just talk about
Those
putting the
terms.
assets
Yeah.
in the trust.
Yeah, so I'll give you an example, and then I'll give you an example about what you're talking about, and thank you for that. That was a really good description about the suitcase.
Keep it simple.
Yeah, it is, it's very simple. So when you create a trust, in order to have that trust govern your assets, you have to transfer title of the assets to the trust, and that occurs in a couple of different ways. So with a house, we do it by recording a deed that says, I own the house, I'm transferring the house to the trust, I now own the house as trustee of my trust. So you still own the house, you can get rid of the trust, you can take the house out of the trust, but you need to have the title reflect that it's in the name of the trust in order for those terms to govern the asset. With other assets, it's a lot simpler to get them into the trust. So basically, we give you a document that you take down to the bank that says, I've created this trust, I have authority to transfer this asset into the trust, I want you to transfer it into the name of the trust. And you essentially will have the same accounts, but they will now reflect the fact that it's part of a trust document, so that those terms govern it. What that does is that really alerts financial institutions, the court, anybody that needs to know that you have created a trust and those trust terms govern that asset. Now, there's some assets that you don't technically put into a trust. So, for example, while you're living and you have your own retirement plan that you've contributed to, that doesn't actually go into the trust. You do what we call beneficiary designations. So it says your IRA, for example, will say, on my death, I want my IRA to go to my spouse. If my spouse is not living, I want it to go to my kids. What you can do in that situation is say, if it's going to go to my kids, I actually want it to go to this trust I set up for them. And that really, there's a way to do it where they'll get the full stretch out of the IRA benefits. They'll actually get it on their own life expectancy. And it still has some protections in the trust that you may have put together that says, I don't want you to be able to pull the money out of the IRA. I want you to, take the distributions. Maybe you can get a third of your trust at age 30, 25, 30, and see how you do with it, that kind of thing. But we really can draft in some protections there.
That's a quick question. So if you're putting your house in the trust, right? Let's say you put it in the trust, and then say now you want to sell the house.
Yeah.
So do you have to file a paper to take the house out of the trust to sell it? Or
No.
can you sell it still sitting in the trust?
It's still sitting in the trust, and basically you're listing and selling and signing all the documents as trustee of your trust.
Mhm.
Now, I know some financial institutions have an issue with refinancing.
Yes, that's what I was
So,
just-
yeah, I mean.
So, yeah, do you want to talk about
No,
it?
it's fine.
I see this over and over again. Clients call me and say, I'm refinancing, or I'm purchasing a car, and they're saying there's challenges with it being in the trust.
Mhm.
You have to stay on top of that and say, I want to purchase this car and put it into the name of my trust. We are refinancing. We have to make sure that this ends up in the trust. It is an extra step for you. It's, again, you just got to go back to that asset has to be in the trust. So through this process, please send me the paperwork confirming that you did the final step, which was putting it back into the name of the trust. And on the beneficiaries topic, I want to just bring up, because this is something I review with my clients every time they come in. Who are your beneficiaries on your IRA accounts? Who's your primary? Who's your contingent? Who's your beneficiary on your life insurance policies? Who do we have your brokerage account in the name of the trust? Do we have your checking savings in the name of the trust? You would not believe how many people come to me from other firms or just are not actively having assets managed. They haven't looked at their beneficiaries in years. Beneficiaries are absolutely critical. You don't want your ex-husband getting your life insurance policy, which I've seen.
Yeah.
And so beneficiaries are something, and it's in my in the binder I created, one place for you when you pass. Make a list for your heirs of this is who the beneficiary is. Here's a copy of my IRA that shows it from Schwab. Here's the beneficiaries. Here's my beneficiaries on my life insurance policies. So beneficiaries are a big deal, and you really do want to have a primary and a contingent. A contingent means if you and your partner pass away at the same time, or you and your primary, who then does the money go to?
Right.
Don't think, oh, we don't need contingents. We need contingents.
So on the beneficiaries and the contingent beneficiaries.
Yes.
At work, they are now requiring us to give them the social security numbers of the beneficiaries. I'm not totally 100% comfortable doing that. I mean, I'm gonna do it because they're requiring it now.
Yeah.
Before it was, they didn't require it, they suggested it, but now this year they're requiring it, and they're saying that if we don't give it to them, that they won't get the funds. So
The challenge becomes, you put, I want my primary beneficiary to be my sister, Jane Smith. And you put Jane Smith, sister. Well, you pass away. Finding Jane Smith, it can be a challenge. And especially when there's 200 Jane Smiths in California. So that extra step is again, yes, there's that risk, as we just saw with Equifax. There's that risk of security, but it kind of is part of the formula. And again, it's part of it. Yeah, but I'm glad that what's also too is some of these companies are really requiring that you have beneficiaries, so that's great. Yeah.
Michelle, are you going to be going over the process of creating this trust today?
Oh, that's a good question.
I can,
Kind of
it's
the
actually
steps.
something
Yeah.
I do, so,
That's great.
and I can go briefly over that. I did want to touch on one thing you said, which is, I can't believe how important it is, and people just, they don't know to do this, which is keeping a copy of your beneficiary designations, because I can't tell you how many times you call the IRA when somebody has passed away. If you're not the beneficiary, they will not talk to you.
No.
So you cannot figure out who it is, and if you can't figure out who it is, sometimes the IRA holder will say, well, there's no beneficiary, and that means it goes back to their estate and you've got a probate. And that's just, it's just a nightmare. You've done this beautiful planning and it can really fall apart. So in terms of going over how to create a trust, just very briefly, basically I do an intake. I go through the assets you have, what heirs you have, if you have kids, really go through the process with you of determining what your goals are and what assets you have, and those are two really big determining factors in terms of the design of the trust and the estate plan that we do. After getting that initial information from you, I draft the documents. I send them to you with comments in the margins that kind of explain this is what this section means. Here are some options in terms of how we can design this section. And then we have a call and we say, we go through all of these things, and you may come back and say, I really don't like this section, or I don't understand what this one means, or can we try this other thing? There is some room for creativity in the document, and people have some very specific ideas about what they want to have happen, and usually we can make that happen. Eventually you get a final draft once you've gone through all your questions, and then you come in and you sign everything, and it's legally effective that day.
Where is it then stored or recorded?
So I usually recommend the clients keep their originals themselves, and Michelle has developed this great binder that you can put it in, and I really recommend that you keep all of your important documents in one binder, which I think yours does, and then you keep that binder in a specific place. Everybody's got a special place they keep important documents, whether it's a locked file cabinet or it's a safe deposit box. But as an attorney, I also keep electronic copies. And I tell people, you tell whoever's going to take over decision making for you when you pass away, here's where I'm keeping the binder, here's the name of the attorney who did it. Call the attorney when this happens, and I can send electronic copies if they are the responsible party. And so that's really the way to kind of make that happen if something happens to you.
Can I ask one more? So that's exactly what I tell my clients. Let's have a safe place where it goes, ideally safe in your home. But the kicker is, and this is why I created this binder, is because my OCD years ago is clients would come in and I'd say, God forbid something happens to you. I got a lot of information about you. We have your financial plan. I have who I'm calling if something happens. I have your budget. I know where all your accounts are. I'm pretty dialed, but who's gonna call me if something happens to you? Well, I haven't told my sister to call you. How am I gonna know if something happened to you? And then, okay, where are you hiding your estate plan and your binder? Oh, it's in the safe. Well, what's the safe code?
We have a document that puts that into the trust. The main things you don't put in a trust are retirement plans and life insurance. Now, you can make the trust the beneficiary of those plans, but the trust doesn't own those plans.
Stocks and, well, that's brokerage.
Yep,
Brokerage
yep,
accounts,
that's
exactly,
brokerage.
yeah, bonds, any
Just think
paper bonds or
anything-
certificates,
That's a
anything
great way.
like that.
Non-retirement and life insurance stays out of the suitcase, goes in the purse. Okay? Everything else.
Question, you probably go through this. So if you're married and you're setting up a trust,
Right.
right? So I guess both parties have to be there to do that. Am I assuming that? Or can you set up a trust?
Good
So let me
question.
ask, because I'm wondering, you know, things are fluid in people's lives.
Yeah,
So let's say you're
yeah.
happily married today, you do all this lovely stuff,
Right,
and then, you know, you're not married anymore.
right.
And then all this stuff is set up together. So is it better to, how do you then protect yourself
Right.
in all that?
So there's different, there's a lot of things interplaying there, so I'll try to touch on them briefly. First of all, most couples will do what we call a joint living trust, which is husband and wife. But in that process, they designate, okay, these are what we call community property assets, which means we got these assets together while we were married. And California says that means each of us owns a half of that. However, there's other assets. I got assets, you know, I inherited assets from my family. My husband inherited assets from his family. Those are what we call separate property in California. Either you owned it before you got married, you inherited it or got some kind of gift while you were married, or you acquired it after you were married. Those are separate property. And you can actually list different schedules on your living trust that says, this is mine, this is his, this is ours. And then if you go through a divorce, you will end up redoing your estate plan so that you separate those things out. And the family court may have something to say about that depending on how involved your divorce is.
Okay.
But you can also do separate trusts. Like if you kind of feel like there might be something on the horizon, you certainly can do your own trust, which governs your separate property and your half of the community property.
Okay.
Mhm.
Okay.
I think the
That answered the question.
inheritance is a big one too for children,
Mhm.
is inheritance is separate property.
Right.
So as we get into kind of charities, and also I call, you know, some of our older children sometimes are charities. I said that delicately since we're being taped. You want to make sure if your son is married to a lovely woman, but you want to make sure that that inheritance gift stays with your son and is not commingled with this beautiful young wife of his, and you know, you need to work through that with your financial planner or your estate planning attorney, is what does your gifting strategy look like to both children and to potentially institutions? Or, for example, I have many of my clients who are so blessed and they have so much more money than they will ever go through in their lifetime. And so we are now getting to this place where many of you are too young in this room, where they're over 70 and a half. You are required to take a distribution when you hit 70 and a half from your IRS. Thank you, government. You have to take money out. And so parents are either maybe starting to give to their children. They could give to, I have clients and friends gifting back to the college for scholarship dollars. And if we do it correctly from their IRA accounts, it comes out tax-free. First, we make the check payable to St. Mary's College or to the Cancer Society. Then we give them the required minimum distribution. Then we get some tax benefits. So when we get into gifting either to children, gifting into institutions, you really need to talk that through and have a strategy with your estate planner and your advisor so that it's done correctly.
And I think this is another reason to kind of point back to the incapacity planning, because if you don't have your incapacity planned out, you can't continue that gifting. So you can do a durable power of attorney, and if you don't have it specifically listed in there that they're allowed to either gift money from your IRA or gift money from your trust, if you're in the habit of giving your kids money at certain stages in their life, that may not happen. Now, the kid may try to go to court and make that happen, but it's going to be a battle and it's going to be expensive. So I think people are always surprised at what can fall apart if something happens to them.
So say that again, actually, it's been a while since
Sure.
So if someone becomes incapacitated, they need to clearly have in their estate plan
that they can
the
continue a plan of
trustee
gifting.
has the ability to continue their gifting strategy.
Not just the trustee, but the agent under the
The
durable
agent.
power of attorney. And in California, in order for you to be able to give money out of the trust, both the durable power of attorney and the trust have to say the same thing or it won't work. So there's a lot of technical planning involved there just to make sure you can keep doing what you've been doing.
Yeah, you mentioned earlier that when your children inherit the IRA benefits, that you should set up or have set up a trust to allow them to take those benefits rather than in a lump sum over a period of time. I was advised that might be something you would do at the time of, say, the first, we have a joint trust. So if your spouse dies first, then you could set that up. Or is that something that is set up? When do you do that for the inheritors, basically, the beneficiaries?
Sure, and let me just clarify my comments too. So the issue that I was referring to was if your child inherits an IRA outright, they have the ability to withdraw that money. So if they're not financially sophisticated, or they might have some situations in their life where that might look appealing to them, you know, you're not going to be able to prevent that unless you've got it in a trust that says, you know, look, the IRA distributions, minimum distributions go into the trust. You can pull some principal out of the trust at age whatever. You know, you have the ability to kind of stretch that out.
Does that make sense to you?
Well, yeah, I've got older children, so it's not an issue of their incapacity. It's,
Right.
it's the tax advantages to them in relation to their taking it out and not having to pay because I inherited some money and we had to pay.
Yeah.
Because it came out of an IRA, and the person who gave it to me hadn't been paying taxes on it, so it was non-taxed money. So the inheritors basically had to pay tax on the money. And I was wondering whether there's a way of setting it up so that the inheritors of the IRA benefits do not have to pay the taxes.
Right.
You get the point?
I think.
So, yes. $1 million question, how do we avoid taxes? So, it is very clear, and I just spoke to a reporter yesterday who called me and wanted to talk about how can non-married couples, what are the benefits of non-married couples versus married couples when they pass with this situation. Because married couples, remember, if you're primary beneficiary, your IRA goes straight to them. If you are with a partner, your IRA they are inheriting an asset and they need to take a required minimum distribution. They can take it out in lump sum and go buy a Porsche, which I have seen, and it kills me, the kids, and I'm going to use your word, not financially sophisticated. That's my new word. But your inheritors, if they are not your spouse, they have the right, if they are, they are beneficiaries, to do whatever they want with that money. We hope that they're going to go through the whole planning process and take very strategic draws or just the required minimum distributions over their lifetime. But they cannot avoid the taxation. They have to pay the taxes on the required minimum distribution. If their required minimum distribution is $14,000 and they want to go take $50,000, they have to go pay the taxes on the $50,000.
But here's where trust comes into play, because if you have designated the trust as so let's say you have your spouse as your primary beneficiary and then a trust set up for the kids as a secondary beneficiary, the trust gets those required minimum distributions, even though it's spread out over the life expectancy of that child. The distributions go into the trust, and the trust may say something like, you can only take principal under these circumstances. So the trustee is not going to pull extra money out of the IRA. They're just going to get those required minimum distributions. So you're not dealing with that tax piece. And then you can sort of filter the money to the kids however you decide. And you may say you can pull whatever principal you want out of the trust. but they still don't have the authority to liquidate more in the trust than the RMDs.
Okay, thank you.
If it goes to the trust, yeah.
If it goes to the trust, yeah.
So, on the IRA, is it based on your age that you're passing on if they have to have the required distribution? Or would they be able to roll it over if they're still underage?
Ask your question another way?
Okay. So if you have an IRA and you're over 70 and a half.
Right.
and
Okay,
you
so you
pass
have an
away.
IRA. You
I have an
pass away.
IRA and I'm 72 years old.
Got it.
Yeah.
And I pass away and I send it to my heirs. Are they required to continue taking my minimum distribution?
No.
Or would they, if they're only 50, be able to roll it over into another device of their own?
Yes, so the way it works, that's a great question. You're 72, so you're over the required minimum distribution. If you had a draw that we had to take that year that was $22,000 and you did not take it in 2017, we would need to do that distribution to your heirs, make sure that money goes out. Then we go set up inherited IRA accounts for your beneficiaries, and then the calculation is based on their
Okay.
age. That was a great question, yeah.
That was the issue I was really driving at.
Okay. Oh, good, good.
I should have asked you, say it another way.
Yeah.
Okay.
I just have one last question. So when you do estate planning, you're doing the trust planning and then the will as well? Are you doing both of those?
Yes, so
Okay.
typical planning involves the trust, the will, the durable power of attorney, the advanced healthcare directive, the HIPAA, all of those documents we talk about. And if you have some special planning like business succession, we may
Okay.
include some other documents.
Okay, thank you.
Uh-huh.
I wasn't aware until today, I have a durable power of attorney and advanced healthcare directive, but I wasn't aware of the HIPAA, which makes sense. I mean, I have power of attorney for my husband who's disabled with his healthcare, but my daughter does not, for example,
Oh.
my children do not.
Right.
So that's something.
Oh, yeah.
Yeah.
Definitely.
Yeah, and so and especially if something were to happen to you and your husband's disabled, the children aren't going to be able to get that information from the doctors. Yeah.
I've actually started, sorry to interrupt, in situations like that with your husband, is we would definitely have the conversation of, do we even want to have your daughter potentially power of attorney on your IRA account? Do we need her to be power of attorney on more things? Because when you do have that situation, you do want to make sure you've got all the bases covered, because a lot of responsibility right now is on you. And if something happens to you, we got to have someone kick into gear. So,
If you've designated someone as the, with durable power of attorney, right? If you've designated someone as an executor,
Huh.
wouldn't they have that power?
No,
No.
no, executor doesn't, okay, so.
Yeah, exactly. Let me go back to the terms. And I apologize. I should have maybe gone through some of the terms. So anything relating to management of a will, anybody who gets to make decisions that are in a will is called either an executor or personal representative or administrator. Those all relate to a will. Anybody that makes decisions regarding a trust is called a trustee.
And then after the original trustees, what are the other ones called?
Successor trustees. Yeah, so
Okay.
you can have backup keeping. Anybody making decisions with regard to your advanced healthcare directive or your durable power of attorney is either called an agent or attorney in fact. So, terms
The
get
successor
confusing.
trustee.
You're the successor trustee.
And it used to be, before we did the trust, I was on all of the checking accounts and savings accounts
Right,
as a signer.
right.
And then when we did the trust, since I'm a successor trustee, I'm no longer on the accounts because
Right.
I'm a successor trustee. So I had to be removed from the accounts because they're the trustees and only the trustees can have the power over the accounts at
Right.
the time until they both pass, and then it would revert to me.
Right, and that's actually a good thing. I know a lot of people think, okay, I'm just gonna manage my situation in the easiest way possible because this is a lot for me to take in. And so they'll put their kids as a joint owner on an account, joint on the house, whatever. The biggest issue there is if that kid gets into a car accident or some other situation and somebody sues them, they can try to go after those assets. You've got a real issue there, and they eventually may not be successful, but you're going to be in court fighting that forever. So I think what you've done is great.
Thank you.
Oh, yes, I did have a question.
she's like, I did have one.
Good though. Back to the actual trust, so you draw up the trust. It doesn't have to be recorded. Is there a benefit if it is recorded? Okay.
The trust or the deed, are we talking
Yeah,
about?
the actual trust, I know the deed has to be recorded, it
Yeah.
has to say the living trust, that's a property,
Right,
all that good stuff.
right.
But the actual trust itself that you draw up and you put everything into this
Right.
suitcase.
Right.
And everything has a name, like Denise Dawson, living trust, you know,
Right.
all the bank accounts, and then the deed reads as the trust, et cetera. The trust itself does not have to be recorded. Is there a benefit if it is recorded?
You typically don't record a living trust. Those really relate to real property transactions, so you're recording a deed. The one instance where you may see some document relating to the trust recorded is if you have a house that's titled in the name of the trust, and the deed is recorded in the county, so the county has a record of this house is governed by this trust, and the trustee passes away or the successor trustee takes over. You're going to record a shorter document called Affidavit of Successor Trustee, and that is notice to the whole world and to the county, public record, that this person has now taken over management of the trust. That allows you to then do things like refinance the house, sell the house, whatever it is you may need to do.
Sorry for my tardiness. I have two questions. First question is, what if all your beneficiaries and trustees die? What happens then? And then in lieu of this recent travesty of Santa Rosa and Napa, that property that were in people's trusts that burn up, what happens? Like, the insurance is going to pay, but does the beneficiary and trustee still get the insurance money for that, and do they have the decision to rebuild or not?
I can talk about that since I lost my home 2 weeks ago.
Oh, I'm sorry.
But we'll get through it.
We'll get through it. Okay.
I'm not gonna cry. I'm not gonna cry. That's why my eyes are a little puffy.
Recovery, yes.
And I was just telling Lisa this morning, when I have time, I'm going to work with the Wall Street Journal or some major publications and write some articles on this, because to see it from the perspective of a woman who has planned in the middle of the night. I'm planning for myself, I'm planning for this client, that client. That's all I do 24/7 is I'm constantly planning. And so I had everything dialed. I had the pictures of my home, I had the perfect amount of insurance. My home went down in Clear Lake, on the lake there. And so there's the emotional side of it, but then there's the reality of, okay, I gotta kick it into gear now. And the financial implications are profound that no one quite understands. Is you have to, the insurance company, you are paying an amount of insurance, and this is one of the many things, it's one of the many pieces of pie I go over with my clients in the full financial plan. Do you meet with your insurance agent every single year? They will not call you to meet. And some do, some are great. But it is your responsibility every year to meet with your insurance agent and say, do I have the right coverage? If my home goes down today, do I have the right coverage? If I get in a car accident and I kill someone, do I have the right liability insurance, umbrella policies? Am I fully curled? You go to the worst case scenario and make sure you have appropriate insurance. I beg you. Because many, unfortunately, are not there. So let's assume, though, your policy says, you know, your home is worth a certain amount, you have a dwelling amount, you have X, Y, Z. You then have to, it's not as simple as, at least with my situation, that they just write you a check and say, okay, rebuild. You need to list out every single thing that is in your home, down to this pen, this cup, how much was this worth, when did I buy it, how much is it going to be replaced for, was this new? If you want to be compensated. So, of course, I love spreadsheets. It's not the end of the world for me to do this, but it's been living hell. Most of my clients, I know, even though I've asked them to, and it's in the binder, please go through your home and take a picture of everything in your home, so God forbid we lose your home, you have that uploaded to the cloud. That's helped me in kind of reassessing. But insurance companies are not just going to pay you out, and then they're going to depreciate what this pen is worth down to 10 cents, and I have to go rebuy the pen for $1, and then they'll give me the 90 cents difference. It is a big journey, a big journey. They do not just write you the check, and it's not that simple. And then obviously there's, the house goes down, do you rebuild? If you rebuild, then they'll maybe pay you the difference of some building upgrades, if you have that in your policy. So, you know, a lot of us just say, oh, we pay our life insurance, you pay these insurance policies, long-term care, another one. 1 in 3 of you by the age of 65 will need long-term care insurance. It is one of the most important. 1 in 1,500 of you will need your home insurance by 65. I'm one of those. You don't need your home insurance as auto as much as long-term care insurance. But we need to, I know you look at these policies like, I don't know what this means. What is all this stuff? Go to the professionals and have them walk you through, please walk me through every line. Empower yourself to understand what you have. Because we plan for the worst, hope for the best.
Somebody who lost her home in the Oakland fire, and Trump endorsed that even
Oh,
more.
you might have to talk to me
One of the
later,
things that might be helpful to you is if you don't have pictures yourself, obviously they all burn up, is you write your friends and say, did you ever come to my house and take a picture? And that's the way we had to do it, is basically ask for our friends. And one good thing I want to tell you is the replacement value of a book that you bought many years ago for $5 is going to cost you $20 today. So in that case, it wasn't used furniture that we were replacing, it was books. But how do you estimate how many books you had in your home? So we measured the width of we estimated the width of a bookcase and the proportion of hardback to paperback, and that's how we couldn't actually, document which books we had, but the value of those books on the insurance claim paid for our daughter to go continue her education, because it was much more to replace them than it was to replace a used sofa. So this thing about replacement value, in most cases it doesn't work to your benefit, but books it does, because it's really costly buying books these days. So if you're ever dealing with an insurance claim around loss of property, keep in mind that people have pictures that you don't remember that they have, and ask them for them, because it can really help you. Anyway,
Thank you. Yeah.
And you do recover. It takes many years, but you do recover.
Yeah. Thank you. So I think, what time is it? 11:20. Hopefully you found value in this seminar. Again, our goal is to empower you, not to have you walk out of here with your head spinning, but to feel empowered that, okay, this is part of my to-do list and I'm just going to keep chugging along. If any of you are interested in meeting with Mercy, I think her cards are in the back. I'm a financial planner, money manager. My cards are in the back. Love to meet with you if you need help. We'd love to do future seminars in different subjects, but we need to know what you want to hear about. So we'd love to hear from you if you say, hey, come do a seminar on what to do if the stock market crashes.
I have a question.
Yes.
In all of this, whether it's the durable power of attorneys or the living trusts and all that, are those just in effect, if you sign them all here in California and good for California laws? What if you were to move, say, to another state? Would that suitcase go with you, or now you've got to go to the other state and redo?
So both. So initially, all of your documents, another state, if you have a document that you have validly executed in the state of California, other states have to honor it when you go to that state. That being said, there are different things that happen in different states, and the biggest example that I can think about in my own practice is special needs trusts that I do. Social Security has different states implement Social Security rules differently. So I have a special needs trust that's valid here in California. I go to Michigan. Most of the terms, it's still a valid trust, they have to honor it, but Michigan may say, well, we have these other rules, we treat this differently, and so you want to then check in with an attorney in that state and make sure there's nothing else you need to update. But it is a legally effective document, but you also should check in with an attorney in that state.
Interesting. Yeah.
So if you own property in different states, do you put it all in California, or
I guess that was our original question.
Right, what do you do?
From the property, so not if you move, but if you have property in other states.
Well, say, yeah, okay, let's
Sure.
just say you do, say you have one in one state and one in the other, let's say you
Yeah.
have one in California and one in Nevada.
Sure.
What do
Sure.
you do?
So I would do a trust, if you're living here in California, I would do the trust here in California. I would list the Nevada property on the trust. And when you have real estate that's in another state, we use an attorney service to just do the deed in that state because every state's deed requirements are a little different. But basically it says, I'm putting it in my California trust.
Okay.
Yeah.
How about assets that are in another country?
That we use international lawyers for.
Absolutely.
So
Yeah, big
every,
can of worms.
every country has different rules about how you can place financial restrictions or authority over real estate. So like in Mexico, it's super easy to make some of your property part of your estate plan here in California. Other countries, like I believe France, doesn't recognize some of the trusts that we set up. And so I work with an attorney in San Francisco that does international transfers to coordinate with whatever your plan is here.
What happens if you go from a community property state to a not community property state? And say your trust is here in California, but you haven't gotten around to refiling it in Idaho. How do they address that? If you were to get a divorce or something, how? Is it the California law where it was filed that
So
takes
your
precedent?
trust government will govern is in the form that it is. So usually you have a California trust that says California law governs, and so you would have to apply California law. That being said, if you go through a divorce in that state, or if you had some asset that didn't make it into your trust in that state, the rules are probably going to be a little different.